There are different laws for attacks that occur from wild animals, domestic animals, and dogs. Let's first talk about what the liability is for wild animals. Some people do have exotic pets. They may have a raccoon or a bear or something like that. In that situation, they can exercise the greatest care in terms of handling their animal. But if you're injured, they are strictly liable. In the situation of a domestic animal, such as a horse or a cow, then the standard is whether the owner was negligent in the way that they kept that animal. What we normally see are cases where a horse or a cow gets loose and is on the roadway at night, and you are the unlucky person driving a car that strikes that animal. In that case, you'd have to prove that there was something not kept up in terms of a fence or a gate was left open. When we talk about dog bite liability, there are actually two ways in which you can recover. The first is a common law remedy, and common law means these are the laws that we inherited from England when we were colonies, and they're decided on a case-by-case basis. For dog bite liability, you have to prove that the person owned the dog, that the dog had vicious tendencies, that the owner knew of the vicious tendencies, and the owner was negligent in either the way they kept the dog, controlled the dog, or warned of the dog. About 100 years ago, our legislature thought that was too tough of a standard. And as a result, they passed a statute that said that you don't have to prove that the owner knew that the dog was vicious. All that you have to prove is that the person owned the dog or kept the dog and that dog caused you injury.